When in employment, you need certain skills to complete your job. A fisherman will need to know how to catch fish, for example. Sometimes, though, it is not enough that you have the skills when something else makes you unable to complete the job. Using the same example, if the fisherman was afraid of going out on the open water, is it discrimination then to fire that person because something special about them makes them less able to do their job? In most cases, Section 30 of the Human Rights Act is an exception to discrimination if the reason you were discriminated against was a genuine occupational qualification. But what is a genuine occupational qualification? That was the question that was answered in the case of Air New Zealand and McAlister. So in broad strokes, how does the law of discrimination work? In New Zealand, for there to be discrimination, you have to prove a number of things. Firstly, you need to prove that the alleged discrimination was a result of an employer's views on one of the prohibited grounds of discrimination contained in Section 21 of the Human Rights Act. Examples of this are sex, race, religion, age, etc. If you can point to the treatment being a result of a characteristic of yourself on that list, then this step is satisfied. Next, Section 22 of the Human Rights Act sets out that it is an offence to A. Refuse work to someone because of the characteristics of that potential employee. B. Treat an employee with detriment or less favour by reason of some characteristic of that employee. Or C. Fire the employee for some characteristic that they hold. Lastly, there needs to be no exceptions that apply to the employer. These are typically very specific, except for Section 30, which is the general exception for occupational qualification. So what happened in this case? Mr. McAlister was a pilot for Air New Zealand, who flew flights mostly to and from the United States of America. In America, there are rules as to how old you are allowed to be when flying a plane. Originally, the Employment Court had found that there had been age-based discrimination on the part of Air New Zealand, and had ordered that remedy be made. Air New Zealand did not agree with this decision and brought the case to the Court of Appeal. The Court of Appeal then found in favour of Air New Zealand. They compared Mr. McAlister to any other pilot who would be unable to fly over America for any reason, and found that he had been treated no differently than any pilot would have been if they too were not allowed to fly over America due to their law. The court used a comparison approach here, as the Section 30 exception, a genuine occupational qualification, can only be determined when we look to see what counts as qualified amongst other comparable employees. In this way, Mr. McAlister could be said to be unqualified for his work. He was incapable of performing his job anymore. Unhappy with this decision, Mr. McAlister took the case one step further to the Supreme Court, where he argued his case. Here, however, the court found in his favour. They did not agree with the Court of Appeal. It was not right to compare Mr. McAlister to any pilot who could not fly over America, but to every pilot that Air New Zealand employed. There was clearly discrimination, as Mr. McAlister had been treated differently than those other pilots, as he was being discriminated on based upon his age. So the court then looked at whether Air New Zealand could rely on the Section 30 exception and claim that age was a genuine occupational qualification. Given that there were other pilots flying other routes who were over that age, it clearly wasn't an occupational qualification, just a qualification for flying over America. So what are the important points of law here? Firstly, when you want to bring a discrimination claim, you must make sure that you are being discriminated against by one of the reasons in Section 21 of the Human Rights Act. A lot is covered in there, but if what you're being discriminated for isn't on that list, then you cannot bring a claim. Mr. McAlister was being discriminated on based upon his age, which was contained within Section 21 of the Act. But do not think all things you might be discriminated on are contained in Section 21. There are certain categories, such as physical attractiveness, that are not covered within that Act. Secondly, a genuine occupational qualification must be something that if you did not have it, you'd be prevented from doing your job at all, not just from doing one part of your job. If you were employed in a storage warehouse, for example, and you hurt your back, you can still work at a desk taking calls. Following on from that point, however, your employer doesn't always need to find you another place if your current job, if it is too difficult for them to do so. This is from Section 35 of the Human Rights Act. What counts as too difficult for an employer to figure out is something the courts will decide on a case-by-case basis.